Aloha, I'm Greg Kim, and welcome to our legal podcast, Lawyers for Lahaina. In each episode, you'll learn valuable information about various legal topics that may be of particular interest to businesses and individuals who lost their jobs or businesses due to the Maui wildfires. So stay tuned for future episodes. If you need any legal help covered by this episode, please reach out to Lawyers for Lahaina at www.lawyersforlahaina.org. Lawyers for Lahaina is a program of the Business Law Corps, which is a legal nonprofit assisting deserving small business owners and entrepreneurs in Hawaii. With me today is Connie Mittendorf. Connie is a lawyer originally from the San Francisco Bay Area who now resides on Maui. He specializes in litigation and has been volunteering his legal services on Maui to help the victims. He is an active member of Lawyers for Lahaina and is here to offer expertise on understanding and negotiating contingency fee agreements. Hi, Connie. How are you doing today?
Doing well. Thanks for having me.
Great. Well, thanks for donating your time and for everything you do, but we'll just jump right into our questions here. So can you help us understand what is a plaintiff's contingency fee arrangement?
Well, generally, a contingency fee arrangement is agreement. It's a legal agreement between a plaintiff, which is a person who's bringing a lawsuit, and an attorney. And the way that it works is the attorney agrees to represent a plaintiff. Usually it's a civil case without requiring any upfront payment. And in lieu of that, they're willing to take the case on a contingency basis. In other words, they just collect any kind of fees out of a settlement at the end of the case. And so basically, if the plaintiff wins the case, then the attorney can take a recovery. And if they don't win, they don't gain recovery, then the attorney doesn't get anything. So it's a good way to mitigate risk for a plaintiff who doesn't necessarily have a lot of upfront funds to fund a lawsuit at the beginning.
Mm-hmm. So it's a way to hire a lawyer without having money.
Correct.
Yes. Okay. So it could be a win-win if you wouldn't have any other alternative for sure. And what are some of the key terms in an arrangement like that the victims should look for in these agreements?
Well, one of the first things to look at is the percentage, contingency percentage that an attorney may take from any settlement that comes out of the case. So typically that can range from 40% all the way down to 25% or below. But it really depends on the specifics of the case, how complicated it is, and what kind of risk there is in terms of taking the case on from the attorney's perspective, in terms of how likely they think there's going to be any recovery. So another thing to look at is the expenses. What you want to look at is who's going to pay for the expenses. So typically in a contingency fee agreement, the attorney will front and pay for the expenses up front. But you should look at what those costs may be, because they can be court filing fees, expert witness fees, deposition costs, litigation costs. And you should look at those expenses in terms of who has to pay for them at the end of the case, and how that is calculated within the contingency fee. Another thing to look at is the scope of representation. So you should look at, in the agreement, is the attorney going to be handling the case all the way through trial? Or are they going to handle it all the way through appeals? What's the scope of what the injury is that they're trying to recover from, and how far they're willing to take that case for you? Because that's going to be in the agreement too. Another key thing to look at is a termination clause. So if down the line, and some of these cases can take a really long time, they could take several years sometimes. So if there ends up being a problem with the plaintiff and their attorney, you want to look at the circumstances of how you can terminate the agreement and how you can part ways, and then how fees and expenses are determined. You also want to look at any kind of conflicts of interest that may arise. For example, in a case where in the case of the Lahaina wildfires, there's a lot of people who have lost their homes, businesses, and in those kind of cases, there may be conflicts of interest that arise because an attorney may be representing several people. So So you want to look at that. You also look at the responsibilities of the parties in terms of what the attorneys agreed to and what a plaintiff agrees to do as well. Those are kind of the key big picture.
That's a great list, Connie. Thank you so much. So obviously there's a lot in this agreement that the client should think about. So you don't want to just sign what's presented to you. Need to read it. What are some like pitfalls? Key things that could go wrong in this kind of relationship.
Well, we just talked about conflicts of interest. So one of the conflicts that's inherent in a contingency fee agreement is that there's a little bit of a risk that the attorney's financial interest might be to settle the case earlier than might be best for a plaintiff in terms of receiving the maximum possible compensation. Some attorneys want to just go in and settle quickly and get their fees as quickly as possible with minimal effort. So there's some risk in that. One of the things to consider is that oftentimes, and not always, but oftentimes in contingency fee agreements, the fees are often higher than what you might find for a standard hourly rate to compensate attorneys. So that really depends on the risk, and that's a source of conflict sometimes. Another thing that comes up is that the attorney is the party that's really controlling the way that the strategy of the case. And so there may be some disagreements in terms of what the plaintiff believes the right way to handle the case is, and the attorney believes the right way to handle the case is. So it's important to have a good relationship with your attorney so that you can understand and get on the same page in terms of what the appropriate strategy is. And another thing is you don't really know what the outcome is going to be. Oftentimes, it's hard to know. You can make your best estimate in terms of the way you think things might happen, but litigation is inherently unpredictable. So that can be a conflict if people don't see eye to eye in terms of where things end up going down the line. So there may be issues in terms of settlement. So sometimes if, as we spoke about before, where an attorney may have an incentive to settle a little sooner, there may be disagreements in terms of pressure from the plaintiff's attorney to try to pressure the plaintiff to settle a case earlier than the plaintiff may be comfortable with. So those are all things that can lead towards potentially an attorney and their client splitting ways. And that's why termination agreements an important, the termination clause rather is the important thing to look at, an important thing to look at.
And so if the client can afford to hire an attorney using their own funds, that might prove to be more profitable for them in the long run.
That's possible. I mean, you really need to look at the circumstance of the case, and you got to understand what is best for you in your own particular circumstances.
Okay. In the time we have left, maybe you could help us address if someone's approached by a lawyer, what should they do?
Well, you should really assess your own situation about it, and you really want to be comfortable with the attorney that has approached you, and you want to make sure that they're reputable. So one of the things to do right off the bat is research the attorney who has approached you. Look at their firm, look at their qualifications, their experience, their track record, and specifically where they've handled cases that are similar to the ones that you have in front of you. Look at online reviews, testimonials, things like that. So kind of understand their background and their capability of handling your case. You should actually spend some time talking a little further, schedule a consultation, and discuss the case in more detail with them. If you can get a second opinion from someone who happens to know them, that's a good thing to do. And if you can speak to multiple attorneys, that's good as well, so that you can kind of understand options of what your options may be in terms of potential attorneys and firms that you could go with besides just one person. Another thing is you really want to review the contingency fee agreement that they've presented to you. So go back and look at the things we talked about in terms of percentages and risk and who handles what portions of the case and how fees are distributed. And really, you kind of want to trust your instincts in the case, and you really want to feel comfortable with someone when because they're going to be handling your case and dealing with a lot of very sensitive information. So you want to feel comfortable with them, and your communication and the way that you deal with them is very important.
Excellent. So how long will it take for someone to get their money out of the case? I know that it's not a precise answer, but can you give some indication?
It really depends. Some cases can get settled fairly quickly. I mean, some cases are as fast as a demand letter. In the case of Lahaina, it's most likely going to take quite a while. So, I mean, in similar situations, it's taken years. So, you should really be comfortable in understanding that it can be a very complex process, and the legal process itself can be very time consuming because there's various stages from filing pleadings, discovery in terms of gathering evidence in the case, motions, and there's hearings, and potentially trial at the end of the day. And beyond that, there may even be appeals. So you should really feel comfortable with understanding that it can be a long process.
Thank you, Connie, for your time today. It was excellent information, and watch out for future episodes of Lawyers for Lahaina. If you have questions, please reach out to us on our website. That's a wrap. So until next time, we'll see you again. Ahui ho.